I pulled into my driveway in Phoenix, Arizona on a Tuesday afternoon, completely exhausted from dealing with client meetings all day, when I noticed a bright orange envelope stuck to my front door. My stomach immediately dropped because in the Sunrise Valley HOA community, orange envelopes only meant one thing: trouble. I grabbed the envelope and tore it open right there on my doorstep. The letter inside was typed in bold, aggressive font that practically screamed at me through the paper. Violation notice. Recreational vehicle parking prohibited. Fine, $500. Immediate removal required within 48 hours or daily fines of $100 will accumulate. I read the words 3 times, completely baffled, before looking back at my driveway where my brand new tiny home office sat proudly on a trailer base. My name is Kevin Garcia, and I had just spent $15,000 converting what used to be a basic utility trailer into a state-of-the-art mobile office. I worked as a software consultant, spending most of my time on video calls and writing code, and my actual house was too small for a dedicated office space. The tiny home office was my solution. It looked sleek, professional, with large windows, solar panels on the roof, and wooden siding that matched my house. It was not, by any definition I could think of, a recreational vehicle. I stormed back into my house and immediately called the HOA office. The phone rang 6 times before someone picked up. Sunrise Valley HOA, this is Brenda speaking. How may I help you? Hi, this is Kevin Garcia from 4452 Desert Bloom Drive. I just got a violation notice about parking an RV in my driveway, but I do not own an RV. I have a tiny home office. There was a pause on the other end. Mr. Garcia, anything on wheels that is not a standard vehicle is classified as an RV according to our community guidelines. But it is not recreational. It is literally my office. I work there every day. There is a desk, computers, filing cabinets, office equipment. No bed, no kitchen, no bathroom. It is not designed for recreation or living. Sir, the HOA board has reviewed your structure and determined it violates Section 7.3 of the Community Covenants, which clearly states no RVs, campers, trailers, or similar vehicles may be parked in driveways or visible from the street. You have 48 hours to remove it or the fines will increase. I felt my blood pressure rising. Can I at least speak to someone on the board? This seems like a misunderstanding that we can clear up. The board meets next month on the 15th. You are welcome to submit a written appeal, but the fine stands until the issue is resolved. Have a nice day, Mr. Garcia. She hung up before I could respond. I stood in my kitchen, holding my phone, trying to process what just happened. I had specifically checked the HOA rules before building my office. I read through the entire covenant document, all 47 pages of it. The RV section was clearly about recreational vehicles, motorhomes, campers, boats, and similar items. My office was not recreational. It was a workspace. I paid taxes on it as a business improvement. I had permits from the city. The next morning, I woke up determined to fight this. I printed out every document I had about my tiny office. The building permits, the business license, the tax documents, photographs of the interior showing it was clearly an office, and relevant sections of the HOA covenant that I believed supported my case. I drove to the HOA office, located in a small building near the community center, and walked in with my folder of evidence. A middle-aged woman with short blonde hair sat at the front desk. Her name tag read Brenda. She looked up at me with an expression that suggested she already knew why I was there and was not happy about it. "Mr. Garcia," she said flatly, "what can I do for you?" I am here to dispute the violation notice. I brought documentation showing that my structure is not an RV and should not fall under that section of the covenant. Brenda did not even look at my folder. The board has made their decision. If you want to appeal, you need to submit a written request and wait for the next meeting. The next meeting is not for 3 weeks. By then, I will owe thousands in fines for something that should not be a violation in the first place. Should have thought about that before parking an RV in your driveway, she said, turning back to her computer. It is not an RV. My voice came out louder than I intended, causing an older man reading a newspaper in the waiting area to look up. Brenda's eyes narrowed. "Sir, I am going to need you to lower your voice or leave." I took a deep breath, trying to calm myself. "I apologize. I am just frustrated." "Can you at least look at my documentation? It clearly shows this is a business structure, not a recreational vehicle." She stared at me for a long moment, then reached out and took my folder. She flipped through it quickly, barely glancing at each page, then closed it and handed it back. "Still looks like an RV to me. On wheels, parked in a driveway, violation stands. Who specifically on the board made this decision? Can I speak with them directly?" That would be Patricia Montgomery, our HOA president. She does not take unscheduled meetings. Submit your appeal in writing. Brenda returned her attention to her computer screen, making it clear the conversation was over. I left the office feeling more frustrated than when I arrived. Back home, I spent the next 2 hours crafting a detailed written appeal, citing specific sections of the covenant, city ordinances that classified my structure as an office building, and legal definitions of recreational vehicles. I included photos, permits, and a letter from my accountant confirming it was registered as business property. I drove back to the HOA office and submitted it that afternoon. 3 days later, I received another orange envelope. Inside was a new fine for $300 because I had exceeded the 48-hour deadline. My written appeal was acknowledged with a single sentence. "Your appeal will be reviewed at the next board meeting on September 15th. Today was August 23rd. I called my lawyer, Tom Richardson, someone I had worked with on business contracts before. He listened to my situation and agreed to review the HOA covenant. "This is interesting," Tom said when we met at his office downtown. "The covenant does have language about RVs, but it is specifically tied to recreational use. Your office clearly is not recreational. However, HOAs have broad authority in Arizona, and they can be difficult to fight. So what are my options?" "Well, you can wait for the board meeting and hope they see reason. You can pay the fines under protest and sue them later, or you can move the office, which seems like letting them win on a technicality." "I am not moving it. I spent months designing and building that office. It is perfect for my needs, and it is completely legal according to city and state laws." Tom nodded. "Then we prepare for a fight. I will draft a letter to the HOA explaining their error and the legal issues with their interpretation. Sometimes a lawyer's letterhead is enough to make them reconsider. If not, we may end up in court." Tom sent his letter to the HOA the next day. I felt optimistic that surely once they received legal pushback, they would realize their mistake and drop the issue. I was wrong. 2 days after Tom sent his letter, I got a phone call from an unknown number. I answered it while working in my tiny office, surrounded by 3 monitors and a comfortable desk setup that made me far more productive than I had ever been working from my dining room table. "Mr. Garcia." "This is Patricia Montgomery, president of the Sunrise Valley HOA board." Finally, the person actually in charge. "Yes, thank you for calling. I hope we can resolve this misunderstanding." "There is no misunderstanding, Mr. Garcia. You are in clear violation of community rules. The fact that you have involved a lawyer is disappointing and frankly hostile. We are trying to maintain property values and community standards. Mrs. Montgomery, my office is not an RV. It is a permitted business structure. I have provided extensive documentation. It is on wheels. It is parked in a driveway. It looks like a tiny house or camper. Those are not allowed. This is not complicated. But the covenant specifically refers to recreational vehicles. This is not recreational. The covenant also gives the board authority to interpret rules as needed to protect the community. We interpret this as a violation. You can appeal at the meeting, but I will tell you now that the board is unanimous on this decision. Unanimous. How many board members even looked at my documentation? All 5 of us reviewed your case thoroughly. Our decision stands. Remove the structure or continue accumulating fines. Your choice. She hung up. I sat in my office looking around at everything I had built. The walls were insulated and finished with real wood paneling. I had run electrical lines properly, had everything inspected and approved by the city. The windows were double-paned and energy efficient. My desk was custom built to fit the space perfectly. This was not some thrown-together camper. This was a professional workspace that happened to be mobile, which was actually an advantage since I could theoretically take it with me if I ever moved. The daily fines were now up to $800. I refused to pay them, which I knew was a risk, but I was not going to reward the HOA's unreasonable interpretation of their own rules. Tom advised me to attend the September board meeting in person to present my case. Face-to-face communication can sometimes break through bureaucratic stubbornness, he said. Bring photos, bring your documentation, and stay calm no matter what they say. September 15th finally arrived. The board meeting was held in the community center at 7 p.m. I arrived 15 minutes early with my laptop, a folder full of documents, and a carefully rehearsed statement. The meeting room had about 30 folding chairs arranged in rows, with a long table at the front where the board members would sit. Several other homeowners were already there, presumably with their own issues to address. At 7 p.m. sharp, 5 people walked to the front table and sat down. Patricia Montgomery was in the center, a woman in her early 50s with perfectly styled brown hair and an expression that suggested she had never smiled in her life. To her right was a man in his 60s who looked half asleep, and a younger woman typing on her phone. To her left were 2 more men, one thin and nervous-looking, the other overweight and wearing a polo shirt with sweat stains. Patricia banged a gavel twice. The September meeting of the Sunrise Valley HOA Board is now in session. First order of business, approval of last month's minutes. They went through standard procedural items for 20 minutes while I waited, my leg bouncing with nervous energy. Finally, Patricia looked at a paper in front of her and said, "Next, we have an appeal from Kevin Garcia regarding violation notice 2447. Mr. Garcia, you have 5 minutes to present your case." I stood up and walked to the front, setting up my laptop to display photos on a screen they had mounted on the wall. "Thank you for hearing my appeal. As you can see from these images, my structure is a fully functional office space. It contains a desk, computer equipment, filing cabinets, and office furniture. It has no bed, no kitchen, no bathroom, and no recreational amenities. It is not designed for camping, travel, or living. It is purely a workspace." I clicked through photos showing the interior, the electrical panel, the solar setup, and the exterior design that matched my house. I have city permits that classify this as an accessory structure for business use. I have tax documentation showing it is registered as business property. The structure is permanently connected to my home's internet and electrical systems when parked. It meets all city building codes and zoning requirements. Patricia held up a hand. Mr. Garcia, we have seen your photos. The issue is not what is inside it. The issue is that it is on wheels, it is visible from the street, and it violates our community aesthetic standards. But the covenant specifically addresses recreational vehicles. This is not recreational. The overweight man in the polo shirt leaned forward. Do you have a current vehicle registration for this structure? Yes. It is registered with the DMV as a utility trailer because it is on a trailer base. That is required for it to be street legal in case I need to move it. So it is registered as a vehicle, he said, sitting back with a satisfied expression. A trailer, not an RV, there is a distinction. Patricia shuffled some papers. Mr. Garcia, I appreciate that you have invested money in this project, but the fact remains that it violates the spirit of our community rules. We do not allow structures like this to be visible from the street. It sets a precedent that could lead to other homeowners parking all sorts of things in their driveways. Today it is your office. Tomorrow someone wants to park a food truck. The next day someone has a mobile home. We have to draw a line. But I am not asking you to allow mobile homes or food trucks. I am asking you to recognize that my office, which is permitted and legal, is not a recreational vehicle and should not fall under that section of the covenant. The nervous-looking thin man spoke up for the first time. Could you not just build an office inside your home, or rent office space somewhere? My home is only 1,200 square feet. There is no room for a dedicated office. Renting space would cost me over $1,000 a month. This was a practical, affordable solution that meets all legal requirements. Patricia looked at the other board members. Does anyone have any other questions for Mr. Garcia? They all shook their heads. Very well. Mr. Garcia, the board will deliberate and provide our decision within 5 business days. You may sit down. Wait, can I not hear the deliberation? Is this not a public meeting? The appeal deliberation is conducted in executive session. It is within our rights according to the bylaws. You will be notified of our decision. Next item on the agenda. I stood there for a moment, stunned that they were just dismissing me like that, but there was nothing I could do. I gathered my things and sat back down, staying for the rest of the meeting just to observe how they handled other issues. They approved a request for someone to install a basketball hoop, denied someone's request to paint their front door blue, and discussed whether the community pool needed resurfacing. The whole meeting felt like a power trip, with Patricia making arbitrary decisions and the other board members just nodding along. 5 business days later, I received a certified letter. Dear Mr. Garcia, after careful consideration of your appeal, the board has voted 5-0 to uphold the original violation notice. Your structure remains in violation of Section 7.3 of the Community Covenants. Fines will continue to accumulate at a rate of $100 per day until the structure is removed. Total fines currently owed, $2,800. Please remit payment or remove the structure immediately. Failure to comply may result in a lien being placed on your property. I immediately called Tom. They denied it, 5-0 vote. They are threatening a lien now. Okay, this is moving into litigation territory. I can file a lawsuit challenging the HOA's authority to fine you for a structure that does not actually violate the covenant as written. But you need to understand, this could take months and cost you several $1,000s in legal fees. I do not care. This is wrong and I am not backing down. All right. I will draft the complaint and file it with the court. In the meantime, do not pay the fines. If you pay them, it can be seen as admitting you violated the rules. Tom filed the lawsuit the following week. In it, he argued that the HOA was overstepping its authority by applying RV restrictions to a non-recreational structure, that they were violating Arizona state laws regarding HOA governance, and that their interpretation of the covenant was arbitrary and capricious. He requested that the court issue an injunction stopping the fines and declare that my office did not violate the covenant. The HOA hired their own lawyer, a firm that specialized in representing homeowner associations. This was clearly not their first rodeo. They filed a response claiming that the board had wide discretion to interpret covenants, that my structure fell within the plain language of the RV restriction, and that my lawsuit was frivolous. While the legal process crawled forward, my life became increasingly complicated. The fines continued to accumulate, now totaling over $5,000. I received threatening letters weekly. Other homeowners in the neighborhood started treating me differently. Some were supportive, having had their own battles with the HOA, but others seemed to view me as a troublemaker who was bringing down property values. One afternoon in early October, I was working in my office when someone knocked on the door. I opened it to find a woman in her 30s with blonde hair pulled back in a tight ponytail, holding a clipboard. Kevin Garcia. Yes, I am Susan Mitchell. I work for the HOA management company. I am here to conduct an inspection of your property for ongoing violations. I did not agree to an inspection. Per the covenant, the HOA has the right to inspect properties for violation verification. I need to document your structure for the board. Document away from the street. You are not coming into my office. She made a note on her clipboard. Refusing inspection, noted. That is another violation, by the way. Failure to cooperate with HOA requests. That is a $200 fine. Of course it is. You know what? I have had enough of this. I pulled out my phone and started recording. State your name and who you work for again, please. Her professional demeanor cracked slightly. Sir, you cannot record me without consent. Actually, in Arizona, I only need one-party consent to record conversations, and I am that party. So again, state your name and purpose. She turned and walked away quickly, getting into a white sedan and driving off. I felt a small surge of satisfaction, but it was short-lived. 2 days later, I received another violation notice for hostile and aggressive behavior toward HOA representatives with a $500 fine. I forwarded everything to Tom. They are just making things up now. This is harassment. Good, actually. Every unreasonable action they take strengthens our case. Keep documenting everything. In late October, we finally had our first court hearing. It was just a preliminary hearing to discuss the injunction request, but I was hopeful that a judge would see how absurd the HOA's position was. Judge Michael Harrison presided over the case. He was an older man with gray hair and reading glasses perched on his nose. Tom presented our argument, showing photos of my office, the permits, the tax documents, and examples of actual RVs to demonstrate the difference. The HOA's lawyer, a woman named Rachel Stevens, argued that the covenant was clear and that the board had the authority to make these determinations. Your Honor, if we allow Mr. Garcia to keep this structure, it opens the door to all manner of vehicles and trailers being parked in driveways throughout the community. The board must have the authority to maintain community standards. Judge Harrison looked at the photos. Counselor, this does not look like a recreational vehicle to me. It looks like a small building on a trailer. Exactly, Your Honor. A building on a trailer, which is essentially a mobile home or RV. The covenant prohibits these types of structures. But it is not used as a home. It is an office. The use is irrelevant. It is the form that matters. It is wheeled, it is mobile, and it is parked in a visible location. The judge turned to Tom. Does your client's deed restriction specifically define what constitutes an RV or recreational vehicle? Tom nodded. It does, Your Honor. Section 7.3 states, and I quote, "No recreational vehicles, including but not limited to motorhomes, campers, travel trailers, and similar vehicles designed for recreational or camping use, shall be parked in driveways or visible from the street." The key phrase is designed for recreational or camping use. My client's office is not designed for either purpose. But it does say including but not limited to, which suggests the list is not exhaustive, Judge Harrison observed. True, Your Honor, but the phrase similar vehicles designed for recreational or camping use limits the scope. All the examples given are recreational in nature. An office is not similar to a camper or motorhome in purpose or design. Judge Harrison took off his glasses and rubbed his eyes. This is an interesting case. I am going to take the injunction request under advisement. In the meantime, I am ordering the HOA to pause any collection efforts on the fines until I make a determination. Mr. Garcia, you will continue to not pay the fines, but you also will not remove the structure. Everyone stays in place until I decide whether this injunction is warranted. We will reconvene in 30 days. It was not the immediate victory I hoped for, but at least the fines were paused. Tom seemed pleased. The judge is clearly skeptical of the HOA's position. That is a good sign. November arrived, and I continued working in my office, now with a heightened sense that I was in the middle of a legal battle that had taken on a life of its own. My neighbors were split. Some came by to express support and share their own HOA horror stories. Others left passive-aggressive notes on my door about property values and following rules. One evening, I was working late when I heard voices outside. I looked out the window to see Patricia Montgomery standing in the street with two other people I did not recognize, pointing at my office and taking photos with her phone. I grabbed my phone and went outside. "Can I help you with something, Mrs. Montgomery?" She turned to me with a cold expression. "Just documenting ongoing violations for the board records. You know there is a court order pausing any action on this issue, right?" "I am aware. This is for documentation purposes only." One of the people with her, a man in his 40s wearing an expensive-looking suit, stepped forward. "Mr. Garcia, I am Dale Peterson. I live 3 houses down. I have to say, your little project here is affecting all of our property values. Some of us are trying to sell homes in this neighborhood. My office is a legal structure that increases my property value because it is an improvement. If anything, it shows that this neighborhood allows for innovative home business solutions. It looks like a camper trailer. It is an eyesore." "That is your opinion. The city approved it. The state laws support it. Only the HOA has a problem, and they are misinterpreting their own rules." Patricia cut in. "Mr. Garcia, you are not going to win this fight. The board has resources and legal expertise. We have defended this community against people like you before. You should cut your losses, pay your fines, and remove that thing before this gets worse for you." "Are you threatening me?" "I am advising you. There are other enforcement mechanisms available to the HOA beyond fines. We can put a lien on your house. We can take you to arbitration. We can make your life very difficult. You are already doing that, but I am not backing down because I am right and you know it." Dale shook his head. "This is exactly the kind of attitude that ruins neighborhoods. People who think they are above the rules. I am not above the rules. I am following the rules correctly. You all are the ones making up interpretations that do not exist in the covenant." Patricia turned away. "Come on, Dale. We are wasting our time. He will learn the hard way." They walked off, leaving me standing in my driveway, my hands shaking with anger and frustration. I went back inside and called Tom, even though it was after 9 p.m. They were just here outside my house, taking photos and making threats about liens and other enforcement. "Did you record any of it?" "No, I did not have time to start recording before they left." "Okay, write down everything they said while it is fresh in your memory. If they keep showing up, that could constitute harassment, which would strengthen our case further." The 30-day waiting period felt like an eternity. Thanksgiving came and went. I spent it with my parents in Tucson, explaining the whole situation to them. My father, a retired contractor, was furious on my behalf. HOAs are a racket. They exist to make people miserable and collect money. "You are doing the right thing fighting them." My mother was more worried. "But Kevin, what if they put a lien on your house? What if this affects your credit? Then I will deal with that. But I am not letting them bully me into removing something I built legally and have every right to keep." Finally, in early December, I got the call from Tom. Judge Harrison issued his ruling on the injunction. We won. He is ordering the HOA to stop all fines and collection efforts related to your office. He found that the covenant's language clearly limits the RV restriction to recreational vehicles and that your office does not meet that definition. I felt a wave of relief wash over me. So it is over. Not quite. This is just the injunction. We still have to go through the full trial to get a permanent ruling and potentially recover damages for the harassment and wrongful fines. But this is a major win. The HOA cannot touch you while the case proceeds. How long until trial? Probably another 6 to 8 months. Court schedules are backed up. I was not thrilled about dragging this out further, but at least I could work in peace without threats hanging over my head. I celebrated that evening by ordering pizza and working late in my office, which hummed quietly with the sound of my computers and the gentle whoosh of the heating system I had installed. But the peace did not last long. A week after the injunction was granted, I came home from running errands to find a notice taped to my door. It was not from the HOA, but from the City of Phoenix Code Enforcement. Someone had filed a complaint alleging that my structure violated city zoning codes by exceeding the allowable square footage for accessory structures in residential zones. I called the number on the notice and spoke to a code enforcement officer named Marcus. "Sir, I have your permits on file here. Your structure was approved at 120 square feet, which is within the limits, but the complaint alleges it is actually larger than that. It is exactly 120 square feet. I have the building plans and the inspection reports. I am going to need to come out and measure it myself to verify. Can we schedule a time this week?" We scheduled an appointment for Friday afternoon. When Marcus arrived, he was professional and courteous. He measured the exterior carefully, checked his notes, and then nodded. "You are right, it is 120 square feet. Whoever filed the complaint was mistaken or misinformed. I will close this out as unfounded. Can I ask who filed the complaint?" The complaint was anonymous, but it came from someone in your HOA community based on the details provided. Of course it did. The HOA could not find me anymore, so they were trying to get the city to shut me down instead. I called Tom and told him about the code enforcement visit. They are getting desperate. That is good for us. It shows a pattern of harassment that goes beyond normal HOA enforcement. Document everything. Christmas approached, and I decided to decorate my office with lights along the roofline. It looked festive and professional. 2 days after I put up the lights, I got another HOA violation notice for unapproved holiday decorations on non-residential structures. The notice came with no fine attached, since they could not legally fine me right now, but it was clearly meant to intimidate me. I ignored it. I left the lights up through New Year's and into January. Other neighbors started coming by to compliment the office, asking about how I built it and whether they could do something similar. A few people expressed interest in fighting back against the HOA's overreach in other areas. Apparently, Patricia Montgomery had a history of aggressive enforcement, selective rule application, and general power tripping that had affected many residents. One neighbor, a man named Carlos Rodriguez who lived 2 streets over, invited me to a meeting of homeowners who were frustrated with the HOA. About 15 people showed up at his house on a Saturday afternoon. Everyone had stories. They fined me $300 because my grass was a 1/4 inch too long, one woman said. I measured it myself after they cited me. It was exactly the maximum allowed length in the covenant, but they claimed their measurement showed it was over. They denied my request to install a wheelchair ramp for my mother, an older man added. Said it would affect the home's curb appeal. I had to hire a lawyer to force them to approve it. I got fined for having a wreath on my door in January, another woman shared. Apparently, holiday decorations can only be up until January 1st. My wreath was not even holiday-themed. It was just a regular decorative wreath. The stories went on and on. It became clear that Patricia Montgomery was running the HOA like a personal fiefdom, interpreting rules in whatever way suited her preferences at any given moment. Several people asked about my case and whether they could join a lawsuit against the HOA. You would need to talk to my lawyer about that, I said. But the more people who stand up to this kind of behavior, the harder it is for them to continue. We formed a group that we called the Sunrise Valley Homeowners Coalition. We started documenting HOA violations, comparing them to the actual covenant language, and looking for patterns of selective enforcement. What we found was disturbing. Patricia seemed to fine people she did not like for minor infractions, while ignoring the same infractions from people she was friendly with. She had a history of denying requests from anyone who had previously challenged the board on anything. Carlos, who worked as a paralegal, started digging into the HOA's financial records, which were technically public to homeowners. What he found was even more interesting. The HOA was spending enormous amounts of money on legal fees, far more than seemed necessary for a community of 200 homes. In the past 2 years alone, they had spent over $80,000 on lawyers. That seems excessive, Carlos explained at our next meeting. Most of these legal expenses are related to enforcing violations and fighting homeowners in court. They are using our HOA dues to fund what is essentially harassment campaigns. I forwarded this information to Tom. This could be useful. If we can show that the HOA is misusing funds to pursue frivolous enforcement actions, it could lead to the board being removed or at least forced to change their practices. February arrived, bringing with it the discovery phase of my lawsuit. Both sides had to turn over documents and answer interrogatories. Tom requested all HOA records related to my case, all board meeting minutes discussing my office, all emails between board members about my situation, and all financial records related to legal expenses. The HOA's lawyer fought against providing most of these documents, claiming they were privileged or irrelevant. The judge ordered them to turn over the basic documents, but allowed them to withhold some internal communications. When we finally got the materials, they were heavily redacted. But what we could see was illuminating. In the board meeting minutes, there were discussions about making an example of me to discourage other homeowners from pushing boundaries. There were emails between Patricia and the HOA's lawyer discussing creative enforcement strategies. The financial records showed that they had budgeted $15,000 specifically for my case, anticipating it would go to trial. They were planning this from the beginning, Tom explained. They wanted a fight to establish precedent. You just happened to be the test case. So this was never about enforcing rules. It was about power. Exactly, and that helps our case significantly. In March, we had a settlement conference. Judge Harrison ordered both parties to meet with a mediator to see if we could resolve the case without going to trial. I did not want to settle, but Tom advised me to at least hear what they had to offer. The mediation took place in a conference room at a downtown Phoenix office building. Patricia Montgomery was there with 2 other board members and their lawyer, Rachel Stevens. Tom and I sat on the opposite side of the table. A mediator, an older woman named Janet Cooper, facilitated the discussion. Let me start by saying that mediation is voluntary and confidential, Janet began. Anything said here cannot be used in court if we do not reach an agreement. The goal is to find a resolution that both parties can live with. Mrs. Montgomery, would you like to start by explaining the HOA's position? Patricia folded her hands on the table. The HOA's position is simple. Mr. Garcia violated community rules. We enforced those rules. He responded by hiring a lawyer and making this into a federal case, which has cost the HOA significant time and money. We are willing to drop all fines and allow him to keep his structure if he agrees to drop the lawsuit and pay his own legal fees. I started to respond, but Tom put a hand on my arm. Mrs. Montgomery, you left out the part where the judge already ruled that your interpretation of the rules was wrong and issued an injunction in my client's favor. You are not offering to drop the fines out of generosity. You are required to drop them by court order. Rachel Stevens cut in. The injunction is temporary. At trial, we are confident we will prevail. Based on what? Tom asked. The judge's order was pretty clear about the covenant language. The judge was ruling on a preliminary matter. The full trial will involve more extensive evidence and legal argument. Tom pulled out a folder. Let me tell you what will happen at trial. We will present evidence of selective enforcement, misuse of HOA funds, harassment of homeowners, and a pattern of arbitrary decision-making by the board. We will call witnesses from throughout the community who have been mistreated by this board. We will request not just that the court rule in Mr. Garcia's favor, but that the court order a complete audit of the HOA's finances and potentially remove the current board for breach of fiduciary duty. The room went silent. Patricia's face turned red. You cannot remove the board. We are elected officials. You are elected by homeowners and you serve at their pleasure. If you have violated your fiduciary duties, the court can absolutely remove you. It has happened in other HOAs throughout Arizona. Janet held up her hands. Okay, let us take a breath here. Mr. Garcia, what would you consider a fair resolution? I thought for a moment. I want a written acknowledgement from the HOA that my office does not violate any covenant rules and that I am free to keep it indefinitely. I want reimbursement of my legal fees, which are currently around $12,000. I want a written apology for the harassment. And I want Patricia Montgomery to resign as board president. Patricia stood up abruptly. Absolutely not. This mediation is over. She stormed out of the room, followed by the other board members and their lawyer. Janet sighed. Well, that did not go as planned. Mr. Garcia, I want you to know that your requests were not unreasonable given the circumstances. Some HOA cases do settle, but this board seems particularly dug in. Tom and I left the mediation feeling like we had wasted a morning, but Tom was upbeat. This is actually good. They showed their hand. They are not willing to make any real concessions, which means they are either extremely confident or extremely foolish. Based on the judge's prior ruling, I am betting on foolish. We spent April preparing for trial. Tom lined up witnesses from the Sunrise Valley Homeowners Coalition. We prepared exhibits showing the difference between my office and actual RVs. We gathered evidence of selective enforcement and financial mismanagement. Carlos provided documents showing questionable expenditures by the HOA board, including expensive dinners charged to the HOA that were supposedly board meetings, but had no minutes or official business documented. The trial was scheduled for May 15th. As the date approached, I felt increasingly nervous. I had never been involved in a lawsuit before, and the idea of testifying in court was intimidating. Tom coached me on what to expect and how to answer questions clearly and honestly. The night before the trial, I could not sleep. I kept running through scenarios in my head, wondering if I should have just removed the office and avoided all of this. But then, I reminded myself why I was fighting. This was not just about my office anymore. It was about holding an abusive HOA accountable and protecting other homeowners from similar treatment. The trial began at 9 a.m. in a courtroom in downtown Phoenix. Judge Harrison presided. The courtroom was surprisingly full. Many of my neighbors from the Homeowners Coalition showed up to watch. Carlos was there. Even a local news reporter showed up after hearing about the case. Tom gave the opening statement, clearly laying out our argument. Your Honor, this case is about a homeowners association that overstepped its authority, misinterpreted its own governing documents, and engaged in a pattern of harassment against a homeowner who was following all applicable laws. Mr. Garcia built a structure that is legal under city and state law. He obtained proper permits. He registered it correctly. The HOA decided to call it an RV even though it clearly is not, and they have spent months trying to bully him into submission. We are asking the court to rule in Mr. Garcia's favor and award damages for the harassment and legal expenses he has been forced to incur. Rachel Stevens gave the HOA's opening statement. Your Honor, homeowner associations exist to maintain property values and community standards. The Sunrise Valley HOA covenant clearly prohibits certain types of structures from being parked in driveways. Mr. Garcia's structure, regardless of how he uses it, falls within that prohibition. The board acted appropriately in enforcing the rules. The fact that Mr. Garcia disagrees with the rules does not give him the right to violate them. The first witness Tom called was me. I took the stand and he walked me through the entire story. How I designed and built the office, why I needed it, what permits I obtained, how I used it daily for work, and what happened when the HOA sent the violation notice. I explained the appeals process, the board meeting, and the accumulating fines. When Rachel Stevens cross-examined me, she focused on the fact that the structure was on wheels and looked like it could be lived in. Mr. Garcia, is there any reason you could not sleep in this structure if you wanted to? I suppose physically I could, but I would not because it has no bathroom, no kitchen, and no bed. It would be extremely uncomfortable. But it is possible, so it could be used as a living space. Technically, I could sleep in my car too, but that does not make my car a house. Your car is designed as a vehicle. Your structure is designed as a living space. No, it is designed as an office. That is why it has a desk, office chair, filing cabinets, and computer equipment instead of beds, kitchen appliances, and bathrooms. She moved on to questions about whether I consulted with the HOA before building the structure. I explained that I reviewed the covenant carefully, and determined that my office did not fall under any prohibited categories. She tried to make it sound like I had intentionally hidden the project from the HOA, but I countered that I had no obligation to get pre-approval for something that did not violate any rules. After my testimony, Tom called several of my neighbors who had witnessed the HOA's behavior. One woman testified about how Patricia came to her house and told her that, if you support Kevin Garcia, the board will remember that when you submit any requests. Another neighbor testified about the code enforcement complaint that was clearly filed by someone from the HOA, describing it as retaliation. Carlos testified about the HOA's financial records, pointing out the excessive legal spending and the lack of transparency. The board budgeted $15,000 just for this one case before they even issued the first violation notice, Carlos explained. That suggests they were planning for litigation from the beginning, which raises questions about whether this was ever about enforcing rules or if it was about something else. Then Tom called an expert witness, a real estate attorney named David Chen who specialized in HOA law. David testified about proper interpretation of covenants and the standards boards should use. In my professional opinion, the covenant language clearly limits the RV restriction to vehicles used for recreation or camping. Mr. Garcia's structure is neither. A reasonable board would have recognized this distinction. Rachel Stevens tried to undermine David's testimony by pointing out that he had no specific experience with Sunrise Valley's covenant, but David held firm. I have reviewed hundreds of HOA covenants throughout Arizona. The language in this one is standard. It is not ambiguous. The board chose to interpret it in an overly broad way that is not supported by the actual text. The HOA's main witness was Patricia Montgomery herself. She took the stand and Rachel walked her through the board's decision-making process. According to Patricia, the board carefully considered my appeal and determined that my structure violated community standards. We have to think about the long-term impact of our decisions, Patricia testified. If we allow one person to park a tiny house in their driveway, what is next? Food trucks, mobile homes. We have to maintain standards. When Tom cross-examined her, he was merciless. Mrs. Montgomery, is it true that you told neighbors if they supported Mr. Garcia, the board would remember when they submitted requests? I may have said something to that effect, but it was taken out of context. What context makes that statement acceptable? I was simply pointing out that the board considers community harmony when making decisions. So you were threatening retaliation against homeowners who disagreed with you. No, that is not what I said. Tom pulled out documents. Mrs. Montgomery, I have here records showing that the HOA board budgeted $15,000 for legal fees related to Mr. Garcia's case before you even sent the first violation notice. Why would you budget that much money before any dispute arose? Patricia stammered. That is a standard budget allocation for potential legal matters. But this specific line item says Garcia enforcement action. How could you have a specific budget item for enforcement against Mr. Garcia before you had even cited him for a violation? I do not handle the specific budget details. You would have to ask our treasurer. Your treasurer is sitting right there. Tom pointed to one of the board members in the gallery. But you did not call him as a witness, did you? Is it because the budget reveals that this was a planned action rather than a simple rule enforcement? Rachel Stevens objected. Your Honor, counsel is badgering the witness and speculating. Judge Harrison sustained the objection, but the damage was done. The timeline made the HOA look vindictive and calculating. Tom continued. Mrs. Montgomery, have you ever allowed other homeowners to have structures in their driveways? only standard vehicles. What about Michael Peters at 4821 Desert Bloom? He has a boat on a trailer in his driveway. That is different. How? A boat is a recreational vehicle designed for recreation. Boats are specifically allowed under Section 7.4 of the Covenant. Tom pulled out the covenant and read aloud. Section 7.4 states, boats must be stored in garages or behind privacy fencing and may not be visible from the street for more than 48 hours. Mr. Peters' boat has been in his driveway for 6 months. I have photos. Why have you not cited him for a violation? Patricia shifted uncomfortably. I was not aware of that situation. You are not aware even though you drive past his house regularly. Or is it because Mr. Peters is friends with you and you chose not to enforce the rules against him? That is not true. Is it also not true that you approved a storage shed for Margaret Wilson, even though it exceeded the size limit in the covenant? I do not recall the specifics of that approval. Tom kept going, rattling off example after example of selective enforcement, each one documented with photos and records. By the time he finished, Patricia looked flustered and defensive. The pattern was clear. The board enforced rules strictly against people they did not like while ignoring violations by their friends. The trial lasted 3 days. Both sides gave closing arguments on the afternoon of the 3rd day. Tom summarized the evidence, emphasizing that I had done everything right while the HOA had acted arbitrarily and vindictively. Rachel argued that the board had acted within its authority and that the court should defer to the board's judgment. Judge Harrison took the matter under advisement. This case raises important questions about HOA authority and the proper interpretation of covenants. I will issue a written ruling within 30 days. Court is adjourned. Waiting for the ruling was agonizing. I tried to focus on work, but I kept checking my email and phone constantly, hoping for news from Tom. The local news station that had covered the trial did a feature story about HOA overreach, using my case as an example. The story got a lot of attention on social media, with people from around the country sharing their own HOA horror stories. Finally, on June 10th, Tom called. We won. The judge ruled in our favor on every point. I felt like I could breathe again for the first time in months. What exactly did he rule? He found that your office does not violate the covenant, that the HOA's interpretation was unreasonable and arbitrary, that the fines were wrongful, and that the HOA must reimburse you for legal fees and compensate you for the harassment. He is ordering them to pay your legal fees of $12,000 plus $15,000 in damages. He also ordered an independent audit of the HOA's finances and put the board on notice that any future retaliation against you or other homeowners will result in sanctions. Did he remove Patricia from the board? He did not go that far, but he strongly criticized her conduct in the written opinion. He called the board's actions heavy-handed and punitive, and said the evidence showed a pattern of selective enforcement and abuse of authority. That kind of language in a court opinion is damaging. It is basically an invitation for other homeowners to sue. The written opinion was 32 pages long. I read it that evening, savoring every paragraph where Judge Harrison dismantled the HOA's arguments. He wrote, "The covenant's plain language limits the RV restriction to vehicles designed for recreation. Mr. Garcia's office is plainly not designed for recreation. The board's attempt to expand the restriction to include any wheeled structure is not supported by the text and represents an arbitrary exercise of authority." He continued, "The evidence shows the board targeted Mr. Garcia not because his structure violated community rules, but because he challenged their authority. The board's pattern of selective enforcement, coupled with threats of retaliation against homeowners who supported Mr. Garcia, demonstrates a troubling abuse of power. HOA boards are granted authority to maintain communities, not to punish residents who disagree with them. The ruling was covered by several news outlets. The story resonated with people who had faced similar issues with their own HOAs. I got emails and messages from strangers thanking me for fighting back. The Sunrise Valley Homeowners Coalition grew to include over 50 households who were inspired to challenge the board's other arbitrary decisions. 2 weeks after the ruling, I received a check from the HOA for $27,000, covering my legal fees and damages. Patricia Montgomery did not resign, but at the next HOA election in August, she and 2 other board members were voted out. New board members were elected who promised transparency and fair enforcement. The new board's first action was to review all pending violations and dismiss those that were based on arbitrary interpretations of the covenant. They established clear guidelines for how rules would be enforced going forward and created an appeals process that included independent review. They also commissioned the financial audit that Judge Harrison ordered, which revealed that the previous board had spent over $100,000 in legal fees over 3 years pursuing enforcement actions, many of which were frivolous. One morning in September, I was working in my tiny office when there was a knock on the door. I opened it to find a woman I did not recognize, probably in her 30s with curly red hair. "Hi, I am Jennifer Evans. I live over in the Westwood neighborhood about 5 miles from here. I read about your case in the news. I am dealing with something similar with my HOA, and I was hoping you might be willing to talk to me about your experience." I invited her in and made coffee. She explained that her HOA was trying to fine her for having solar panels installed on her roof, claiming they violated aesthetic guidelines. But Arizona law protects the right to install solar panels. My HOA is trying to override state law with their own rules. "You need to get a lawyer," I said. "I can give you my attorney's contact information. Tom Richardson. He is excellent with these cases." Over the next few months, I became an informal advisor to several homeowners battling their HOAs. Tom ended up with a steady stream of clients dealing with similar issues. It turned out that abusive HOAs were common, and my successful lawsuit had given people hope that they could fight back. The tiny home office that started this whole ordeal is still parked in my driveway. I work in it every day, and it has become something of a landmark in the neighborhood. People point it out when driving by. New neighbors ask about it when they move in. It represents something bigger than just a workspace. It represents standing up to bullies, demanding fair treatment, and refusing to be intimidated. Patricia Montgomery moved out of Sunrise Valley about 6 months after losing the board election. I heard she bought a condo in Scottsdale where there was no HOA. The irony was not lost on anyone. The new HOA board and I have a cordial relationship. They approved a request I made to add a small deck to the side of my office, acknowledging that it was an improvement to my property. Other homeowners have since gotten approval for their own creative projects that the old board would have rejected. Looking back, I would not say I enjoyed the experience of fighting the HOA. It was stressful, expensive, and time-consuming. But it was worth it, not just because I got to keep my office, but because it showed that homeowners do not have to accept arbitrary authority. HOAs serve an important function when run properly, but they need oversight and accountability just like any organization with power over people's lives. My case set a precedent in Arizona HOA law. Tom told me that several other judges have cited Judge Harrison's ruling in similar cases. The Arizona legislature even introduced a bill to clarify HOA authority and protect homeowners from overreach, though it is still working its way through the process. I still get occasional emails from people across the country who are dealing with HOA issues. I always tell them the same thing. Document everything, know your rights, read your covenant carefully, and do not be afraid to stand up for yourself. Most HOAs will back down when challenged by someone who is clearly in the right and willing to fight. One unexpected benefit of the whole situation is that it brought the community together. The Sunrise Valley Homeowners Coalition is still active, meeting monthly to discuss neighborhood issues and keep the board accountable. We organized a neighborhood cleanup day, started a community garden, and established a welcome committee for new residents. The neighborhood feels more connected now than it ever did under Patricia's authoritarian rule. My tiny home office has been featured in several architecture and design publications. The story of how it became the center of a legal battle makes it more interesting to people. I have had several inquiries from people wanting me to help them design similar structures. I am not planning to start a business doing that, but I am happy to share my plans and advice. Last month, I got an email from someone at a national news magazine wanting to do a story about HOA reform, using my case as a centerpiece. The article ran last week with the title, "The Rise of HOA Resistance: How Homeowners Are Fighting Back Against Overreach." It featured my story along with several others from around the country. The article pointed out that while HOAs serve important functions, there is a growing movement of homeowners demanding better governance and accountability. I framed Judge Harrison's ruling and hung it on the wall of my office. It is a reminder that the legal system, while sometimes slow and frustrating, can work when you are patient and persistent. It is also a reminder that standing up for what is right often inspires others to do the same. The financial compensation I received from the lawsuit more than covered my legal fees. I used the extra money to upgrade the solar panels on my office and to make some improvements to my house. Every time I use that money, I think about how the HOA intended to punish me, but instead ended up funding home improvements. I still live in Sunrise Valley and plan to stay for the foreseeable future. The neighborhood has changed for the better. The new HOA board is reasonable and fair. Property values have remained stable, despite Patricia's dire predictions that my office would cause them to plummet. In fact, several real estate agents have mentioned that the neighborhood's reputation for standing up to HOA overreach has actually made it more attractive to certain buyers who value independence and community solidarity. My tiny home office sits in my driveway every day, a testament to the fact that you do not have to accept unfair treatment just because someone in authority says you must. It is a workspace, a legal victory, and a symbol of resistance against arbitrary power. And every morning when I unlock the door and step inside to start my workday, I feel grateful that I decided to fight rather than give in to intimidation. The whole experience taught me that institutions like HOAs rely on people being too tired, too scared, or too busy to challenge them. They count on homeowners accepting their interpretations even when those interpretations are wrong. But when you stand up with facts, documentation, and determination, the truth has a way of prevailing. It may take time and it may be frustrating, but justice is possible. I hope my story encourages others facing similar situations. Whether it is an HOA, a landlord, a corporation, or any entity trying to push you around unfairly, you have more power than you think. Know your rights, document everything, Find good legal help if needed, and do not be afraid to fight for what is right. The system is not perfect, but it can work when good people refuse to be bullied. My tiny home office is more than just a building on wheels now. It represents freedom, justice, and the power of one person standing up to make things right. And that is worth more than any amount of money or convenience. Every day I work in that space, I am reminded that the fight was worth it, not just for me, but for everyone who will benefit from the precedent we set and the accountability we demanded.